Hi, everyone. My name is Mike Fiffick. I'm an attorney in Pittsburgh, Pennsylvania. My law firm is Fiffick Law Group. I've been practicing for 28 years, and the focus of my practice is businesses and small businesses in particular. I advise businesses from formation through their growth, governance, resolve disputes, litigations, help them do planning and acquisitions and succession planning as well. So really represent business owners of all sizes throughout the life cycle of their businesses. And I'm here to talk to you today about reducing risk and liability. It's something that every business owner is interested in doing. And for some business owners, that's why they form a business entity. Maybe they're already in business for themselves, have a small business that they're doing on their own as a sole proprietorship. And they decide at some point that they need to form a business entity. So I'm here to talk to you today about what types of risk that your business faces, and in particular, what type of risk you and your personal assets face in your business and how to mitigate that risk. So protecting your personal assets is oftentimes the number one reason that my clients who are sole proprietors tell me that they want to form a business entity. They want to protect their personal assets from the risks that arise out of their business. And, you know, that's a good idea. It's a very good idea. But I would encourage folks that are in business to think a little bit more broadly about protecting assets and think about it more of risk mitigation and recognize the types of risks that their business and that their personal assets face as they do business. There are three basic types of risk. They arise out of torts or accidents, injuries, those types of calamities. Contractual risk. Every business is going to have a wide variety of contractual relationships, and there's always liabilities and obligations that come out of those. And then every business is going to be operating in some type of a statutory or regulatory environment that also provides for liability or risk in the event that they fail to comply with whatever those laws or regulations provide. Now, whenever somebody forms a business entity, to protect their assets, I always give them a caveat, right? There's this false sense of security. Don't think that because that you formed a business entity that you're not going to get sued personally. Anybody can sue anybody at any time. I always tell business owners that whether the lawsuit is has a good basis or not, or whether there's a good claim against you personally as a business owner for whatever this business obligation is. Sometimes business owners just get dragged in personally into lawsuits or disputes that are filed against their businesses. And really what I'm talking about here is not something that is a shield against being sued, but is going to give you the best opportunity to get yourself out of the case personally or protect your personal assets from these types of suits. So let's talk first about tort liability. Some examples of tort liability as it relates to your business might be a motor vehicle accident. If you've got delivery trucks driving around, or some of your employees have to drive, maybe you have an HVAC or a plumbing business, or you're a contractor of some kind, you're going to have a lot of vehicles that are floating around out there. And every day that there's somebody driving one of your vehicles, there obviously is a significant amount of risk for having some type of an accident with the vehicle. Slip and fall, another big opportunity for liability, especially for commercial property owners, residential property owners, landlords. They're always worried about somebody slipping and falling on the property and getting sued, as a result of that. There are also some environmental types of liabilities out there. So if you're a property owner, maybe there's mold or some other type of a substance that makes people sick, in the building. So you've got that going on. And then you've got employees out there that could potentially cause injuries to other persons. So that's not uncommon type of a thing that happens out there. Or they cause injury to property, right? Perhaps you're a contractor, you've got employees that are out there and they, make a mistake on a property and end up causing a significant amount of damage to the property, that's going to be liability as well. So this is a potential problem for your business, but it's also a potential problem for you and your personal assets. Because if you have an LLC, a limited liability company, or if you operate out of a corporation or a limited partnership, or any of the other business formations that provide some liability protection, it is still possible for a claimant or a plaintiff, an injured party, to try to sue you and get to your personal assets. And there are two primary ways that they do that. One is called participation theory, and the other is piercing the corporate veil. Participation theory basically means that if you personally participate in causing the tort, causing the accident, the liability shield of your business entity is not going to protect you and your personal assets from liability for whatever the injuries that you were to cause. So if you personally participate in that, you're going to potentially be responsible for the damages that might ensue as a result of that claim. Now, piercing the corporate veil is a theory that says basically that your business entity that you're operating is really a sham, right? It's just no different than you, and you and your business are basically one and the same thing. So they try to disregard that business entity protection that's out there and just say that whatever claims there are, whatever damages that have to be paid as a result of a lawsuit are going to be payable out of your own personal assets in the event that they are successful. And you can leave yourself susceptible to this type of an argument, and I've certainly defended it many times in the past, when your business is undercapitalized. So if you're drawing money out of the business for yourself and rendering the business incapable or unable to pay its debts and bills and things of that nature, then that's when your business is undercapitalized and you may be making yourself susceptible to this type of an argument. Perhaps you have lax organizational governance documents, so that you say that you're an LLC, but you don't have really any documents to reflect that you are, or the documents that one would normally expect to see for a legitimate LLC or corporation, you don't have them. So your certificate of your operating agreement is not signed, or you don't have one. You've not kept corporate minutes or LLC minutes or resolutions. You've not signed contracts with your business name. You're just signing in your individual name. You know, all of those things fall under that category of lax organizational governance or organizational documents. You know, the paperwork does matter in some respects. Some business owners commingle or intermingle funds, right? They pay their personal bills out of the business account, because that again lends itself to this argument that you and your business are one and the same. You know, under the law, you and your business are two separate people or two separate persons, right? And if you're paying your personal bills out of the business account, or your living expenses are being paid for out of the business account, then again, somebody can say, well, there's really no difference between this business and you. They're one and the same. All of these personal bills are being paid out of the business. Therefore, this business entity is really a sham, and you are personally responsible. In instances where you've committed fraud, where you've tried to defraud somebody, that can also permit the court to find that your corporate entity, that corporate liability shield, can be disregarded. So how do you mitigate tort liability? Well, the number one best way to do it in many instances for most tort liabilities is to buy insurance. That's kind of an easy thing to say, but it's a little bit harder to do in real life. And so what you have to do is find an insurance agent and really talk to them about your business. Don't just let them give you a quote and assume that whatever that coverage is going to be appropriate for you. You don't want to get sued or have a claim that's raised and find out at that time that the insurance that was sold to you doesn't fit your needs. So it's important to sit down with your insurance agent and talk to them and tell them, This is what I do. Let's talk about what risks are out there to make sure that your insurance agent can go out there and shop for the insurance product or riders or additional coverages that are going to provide you the protection that your business needs based upon what you do. You might also look to see, if you're part of a trade association of some kind, to see what types of insurances that they suggest for your type of a business. You know, they maybe have been there, done that, have vetted this, and had the benefit of a lot of minds on it, and they can give you some good guidance and advice on the type of insurance that you should have for your type of a business. You also are going to want to pay attention to the insurances that you're required to have by law. So, for example, if you're a contractor and you're doing work for consumers in Pennsylvania, not only are you required to be registered with the PA Attorney General's office and be licensed, you are also required to have a minimum amount of liability insurance in order to do that type of work legally. Employers who have employees are required to have workers' compensation coverage. You know, those are some examples of insurances that you are required to have as a business owner, and you'll want to check with your check with the state or your regulator or the Bureau of Occupational Affairs, whatever regulates you, to make sure that you're in compliance with whatever insurances are required. Good operations are another great way to protect yourself. So you're going to want to engage in lots of training of your employees, not just once, but on a regular basis. You should commit to regular training to make sure that your folks are doing the best job that they can do in order to avoid tort liabilities, right? Mistakes result in risk and liabilities, and it's important for you to spend time putting in place a system of training and other types of audits and constant maintenance of what your folks are doing in order to reduce the amount of risk and reduce the opportunities for liability. And you want to not do the things that lend yourself to be susceptible to a piercing the corporate veil argument. So make sure that your business is adequately capitalized, that it can pay its bills. Now, not all of them can pay their bills, but make sure that that undercapitalization is not a result of you paying yourself rather than your vendors and your creditors. That's where the issue arises. Make sure that your corporate documents are in order, and that you, if you're operating as a business, make sure that everything that you show to the public from a documentary standpoint has your business name on it. You're signing as an officer of the business. Make sure that you are presenting yourself to the public all the time as your business, not as you. You want to maintain your corporate account separate from your business account, right? Don't pay your personal bills out of the business account. Pay yourself a salary, pay yourself your distributions, do those things, and then pay all of your personal bills out of your personal account. Don't commingle the funds. Those are some key ways of mitigating tort liability and liability in general. So let's talk a little bit about contractual liability. Every business has contracts, right? The contracts that most often give rise to personal liability are loans, commercial leases, vendor agreements, and franchise agreements. It's difficult to obtain what I refer to as non-recourse loans or agreements like these. Non-recourse meaning that the bank, if it's a loan, or the landlord, if it's a commercial lease, are going to want you to personally guarantee your business's obligations to the bank or to the landlord, those types of things. Almost invariably, if you're going to be borrowing money from a bank or anybody that's lending money, they're going to ask you for a personal guarantee. That's a if it's not guaranteed, it's a non-recourse loan. Vendor agreements, supplier agreements in particular, if you're ordering supplies on credit, those credit agreements often have a personal guarantee provision in them, and many business owners may miss that because they might not read it. It's relatively normal. They have those in there, so you got to pay attention to those types of things. I've certainly defended business owners in the past whenever they have a legitimate dispute with a vendor, right? With a vendor, that vendor sues them, they sues the business and sues the business owner individually. That gives the vendor a huge leg up over the business in that dispute, because now the owner personally has skin in the game in that dispute, and it makes it tough for that business owner to vigorously defend that dispute with that vendor and try to get things worked out whenever you're fighting two battles rather than one. So here's some advice for you on mitigating contractual liability. Be aware of and avoid personal guarantees, right? You got to read these contracts. Be aware that you're signing a personal guarantee of some kind. Probably going to be very evident to you on a loan, because you'll sign a separate personal guarantee or a guarantee document. So it's hard to miss that. Although sometimes when you sign for these loans, there are a gazillion papers and you might just be shuffling along. Don't let somebody cover the documents up as you sign them. Make sure you take a look at them. But in particular on your vendor agreements and your leases and things of that nature, those are places where personal guarantees can be hidden from you, and you're going to want to try to avoid those. You know, sometimes those can be negotiated, or you just cross them out and send the document back and just sign on behalf of the business and cross the personal guarantee sections of it out, or just don't sign that part. Send it back to the vendor. You know, the vendor may not be scrutinizing whatever you've sent back to them. Maybe they have just an administrative person that just is checking the box, got the document back, not making sure that it's signed correctly. You know, those are ways that you can try to sidestep some of those personal guarantees out there. But even in those situations where you can't sidestep it, you can certainly try to negotiate personal guarantees out of your agreements, or you can try to negotiate limitations on your personal guarantees. You know, a type of a limitation would be to have it sunset after a period of time. I'll personally guarantee for a year, but after that, the personal guarantee goes away. Or I'll personal guarantee only amounts over a certain amount. There are lots of different ways of mitigating or reducing your personal liability for business debts. Again, maintain your corporate identity on all of the signed documents, putting yourself out there as your business at all times, not you. Whenever you sign documents, you sign them as a representative of the business. You would put your title in there, whether it's president, CEO, managing member, whatever it is. You want to make sure that whenever you're signing something, that you're telling whoever it is on this, whoever the other party is, that you're signing on behalf of your company, making no mistake about that. Be proactive whenever you're unable to meet your financial commitments. You know, this is something that is common whenever you owe somebody money and you can't pay, you try to avoid it. That doesn't do any good. You really want to be proactive. You'd be surprised if you're proactive that, you know, the party on the other side of that is more likely to work with you if you are proactive in communicating with them, making some type of effort to pay, even if it's not everything. That isn't always going to work, but it is far better than sticking your head in the sand, avoiding them, not communicating with the other side, because eventually that's just going to result in a lawsuit. And that's a much more expensive way of resolving that issue. Plus, you may be personally liable for the debt if you've signed a personal guarantee. And then you could always segregate your business lines into different entities. And this is sort of a general risk mitigation technique that you can use. And so if you can do business, if you've got varying lines of business that you do, you know, if you've got more than one business entity, you know, perhaps you can sign contracts out of one business entity, but do some operations out of another. You know, every LLC or corporation or whatever is like a box, and you want to put as few risks in each one of those boxes so that the risks in one box don't infect the assets in the other box. That's another basic technique that can be very, very effective at protecting assets, right? Just keep risks and assets in certain boxes and separate them from one another. So another form of liability is statutory liability. And in particular, for your liability as a business owner, there are some statutory or statutes or regulations or laws that can result in your personal liability. There are a lot of business-specific laws and regulations out there, but the one that can really cause a tremendous amount of consternation is wage and hour laws. and worker misclassification. I'll refer to that as well. They're two sides of the same coin, so to speak. There are federal wage and hour and worker classification laws, and there are state wage and hour and worker classification laws. And then there are even additional wage laws depending on the type of employee that you have and how they're paid. So there's a very broad, complicated matrix of laws out there that relate to paying employees, paying salespeople, paying independent contractors if you have those. And there's a lot of misunderstanding on behalf of business owners about these types of laws, lots of misunderstanding. And it's a big problem because almost in all of those laws, a business owner can be held personally responsible for not only the unpaid wages, but penalties and interest in attorney's fees in the event the employee sues for unpaid wages. So this is a sort of a hidden area of tremendous personal liability for business owners, especially if you're the decision maker in the business, if you have not complied with wage laws. And it doesn't matter whether you've done it intentionally or not. It could be completely unintentional, right? It's still a violation of the law. You have still failed to pay, and you can be personally liable for these things. If you've misclassified workers, this is a big issue that's out there. And I see the misclassification is typically between employee versus independent contractor. You know, some employers think very mistakenly that if they simply pay somebody with a 1099, they're not an employee. That's how you differentiate between employees and independent contractors. That's a big misunderstanding. You could very well be misclassifying an independent contractor out there who's really should be treated as an employee and who you should be paying very, very differently. The misclassification also often occurs between what are referred to as exempt and non-exempt employees, those that you pay hourly and that are owed overtime, and those that you pay salaried and you don't owe overtime to. There's a lot of misunderstanding and mistakes on those types of classification issues, and they can all result in personal liability. Taxes are another big one, and when I say taxes in particular, I'm referring to trustee type taxes, meaning taxes that you collect on behalf of the government and that you're supposed to be remitting to the government. Sales tax, employment taxes. These are things where you're in essence the government's collection agent, and you have to pay that money over to the government once you've collected it within a certain period of time. If you fail to remit those trustee type tax collections, you can be personally liable for those things. Many a business owner keep that money and try to use it to finance their business, typically whenever it's struggling, and that ends up catching up to them, and they can be personally liable for those. So big problem. How do you mitigate those? Well, you've got to be aware and comply with all of these business-related laws. You know, there's guidance out there with the wage and hours divisions of not only your state Department of Labor, but also the federal Department of Labor and the wage and hour divisions. There's a lot of compliance information out there for you, some training that you can undergo. You can spend a lot of time, you know, doing that stuff to try to educate yourself. What I'm going to suggest to you is that you really should short circuit that and just get yourself connected to an attorney that can help you with your compliance. Take a look at your situation, offload that or outsource that to somebody who knows all of this stuff already, and let them just tell you what you're doing right, what you're doing wrong, and how to make some corrections for you. That would be much faster, much more economical. You'll spend a lot less time on stuff that isn't going to grow your business by offloading that to somebody else. And on the subject of access to legal advice, this might be the number one risk mitigation technique for business owners altogether. You got to get with an attorney, right? It's very important for you to do. And I know that a lot of business owners might think that the only time that they need a lawyer is whenever they get sued. They don't get sued that often, therefore they don't really need a lawyer. And I'm going to suggest to you a very short-sighted view of access to legal services. I'd like to invite you to sort of reimagine how you might use legal services, how might you use an attorney if the cost really wasn't so much of an issue. Would you call them more frequently to assist you in your business if you didn't think that the meter was running every time that you talked to your attorney on the phone? I'm going to suggest to you that if that meter wasn't running, here are some things that an attorney could do that would really have a very positive impact on your business and allow you to spend more time growing your business, right? Looking back over your shoulder less frequently over potential issues and risks that are out there, and really allow your business to grow and flourish and be more profitable. You know, an attorney could assist you with all of these organizational documents. We've talked about how important it is, or how bad lax governance documents really are. A lawyer could clean all of those up for you and get those all signed and have them nice and neat and organized, and have them available to you in case you misplace them, and business owners do from time to time, whenever you need them. And you often need them whenever you're borrowing money, signing a lease, buying or selling real estate. Any of those things, you're going to have to produce your corporate or LLC documents as a matter of course. And not being able to produce them can be the difference between getting the loan or not getting the loan. You know, an attorney can talk to you about not only the tax decisions that you've made for your business, but also its business structure. And that can really result in some significant savings for you, dollars and cents wise, if you can make some changes from a tax perspective in your business. And there are lots of different ways that this can have an impact on your business. Doing some organization for your business as well. We talked about segregating your business or segregating your business lines into different units in order to mitigate risk. That's just one business structuring technique that an attorney can help you with that can really protect your personal assets. But you may also want to bring other people as owners into your business. And most business owners that I know have a very straightforward understanding of what that means. You give somebody ownership, that means they've got control and equity, but it doesn't always need to mean it that way. You can talk to an attorney who can help you bring new owners into your business without giving away what it is that you don't want to give away. They can help you with risk mitigation and just talk to you about all of the things that we just talked about to protect your business from liabilities and risks that are out there. They can help you with these employee issues. You don't have to go figuring this stuff out on your own and watch endless hours of videos or scan FAQs and try to figure this stuff out yourself. There are attorneys out there that already know about this stuff and can answer questions for you as they arise, put employee manuals together for you, help you make good decisions about classifying your employees and just avoid significant amounts of risk here. And then also help you avoid potential problems whenever you need to terminate an employee so that you are less worried about having a lawsuit filed after you fired somebody. And I know a lot of business owners are concerned about that. The attorney can look over your contracts and reduce the risk not only to your business, but you personally. All of these techniques that I talked about before about getting rid of personal guarantees or limiting the effect of personal guarantees. An attorney knows what provisions in these contracts can and cannot be negotiated, or techniques on how to mitigate them for you. Again, all of this stuff really matters over the long haul. If you're in it for the long haul, if you're in your business, successful businesses mitigate risk, because risk and liabilities and lawsuits are devastating to businesses. Even if you win the lawsuit, just having to pay the attorney's fees to defend a lawsuit can really be financially devastating to a business. And then attorneys can help you with these compliance issues as well, to help you keep in compliance with your regulatory environment. So that's a little bit about risk mitigation for your business and to protect your own personal assets if you're a business owner. Thank you very much for tuning in to this webinar. I have others on our YouTube page, and we would ask that you would please take a look at those. If you like the video, please like us or leave a comment, share it with your friends. We very much appreciate it. And if you have any questions or comments, my contact information is below. Feel free to reach out. Thank you.